The tribe says, hit the like. Howard County observer says, observing. Howard County observer says, how are you today, tribe? Howard County observer says, activated by the way. The tribe says, excellent. Howard County observer says, nice narrator. Is that an app?
I'm not sure, but here it is.
Joseph figure 5,227 says I am on time.
Excellent, and greetings. Welcome to all. Welcome to Proof and Presumptions of Property Ownership, condensed from American jurisprudence, property. I know we've gone over this before. We've actually gone over this entire volume here from American jurisprudence. However, that was a 2011, and I got a 2022. So we have some updates on some of this, and that's what I built this on, is the ones I found most prominent. With that said, just remind everyone, this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, abused, misconstrued, or misused for anything legal, lawful, personal, private, public, law, tax, financial, business, or otherwise. Please don't do this at home. That said, let's get started. So we're going to be going over the actions, ownership, and proof of property. Starting from section 46, the procedures and actions involving property generally here. And we're going to go over the remedies, trespass, rights of action, and non-possessory interests. The law presumes that the infringement of a property right is harmful and sustains a remedy to vindicate that right and prevent future harm. So that's what the law presumes. Infringement of property is harmful. That's one presumption. The other, that there's a remedy to vindicate and prevent future harm that the court must sustain. The rules and principles relating to actions generally apply to actions relating to real property with the same force as to other actions. So let's look at the rules and principles relating to the actions. As a general rule, only the owner of the fee. Now we're talking about what they say here is real property, immovable property, and a fee is that type of land coming from fief. And it's when there's a freehold on the land, then I think it's just simply called fee in law. But just to be sure, we can always take a quick trip into Black's Law and see exactly fee definition here, as they're going to be using it here for the terminology. So let's just zoom in here a little bit so it's a little bit easier for you to see and for me. And we're looking at 9th edition of Black's Law, and we need to find fee. And this is a scanned version here. So give it a second here to catch up with the scroll. And as we go along here, there's always these serendipitous incidents of different words that always have some like Delaware Trust, see asset protection. That's for another topic there. But let's get to the F's into fee. All right. We're almost there. And if you haven't already, please hit the like. And I believe we do have the talking chat enabled so that if you put something in the chat, it should be reading it back so we can all participate and comment.
The tribe says, hit the like.
Indeed. So let's see here. Boy, it's going kind of slow here. Bear with me for just a moment and we'll be in the F's. Here we go. EX. Oh boy, there's a lot of these. All right, so we'll just jump a little bit further here and get to the F's. There we go, fee. Oh boy, we got a lot here. Fee simple, fee farm, fee estate, plowman's fee, all kinds of fee. We're not talking about the fee you pay, like the base fee here. But here we go, fee from the 14th century. That's not the one we want. That's a charge for labors and services. We need to get to definition 2. Let's see here. Here we go, 2. Okay, so this is still on fee. That was definition 1, all of this. Now we're on to 2. A heritable interest in land. So that's a hereditamент, right? Especially a fee simple absolute. Also termed free estate or freehold estate. I think feud, feudum, fief. See, fee simple. To enfief someone was to transfer him an interest in the land, called a fief. Or if you prefer, a fief, feed, or feud. Our modern word fee, a direct lineal descendant of
Auditum
fief.
says, right on time, shaving my beard and listening to this in the background.
Excellent. Well, and we'll want to be paying attention because there will be a special surprise at the end, so make sure you stay tuned. Let me zoom in a little bit more here because this is getting hard to read. Okay, there we go. The descendant of a fief implies the characteristic of potentially infinite duration, so that's the freehold, when used to describe an interest in land.
Our county observer says, at.
Yes, greetings to audit them, and salute to you for the work you do. All right, so on to our modern word fee, but in the earliest part of the feudal period, a fief might have been as small as a life interest. So instead of an indefinite duration at the beginning of the feudal period, quite some time ago.
Auditum says, hey.
Howdy. So you got to think back then, even a freehold would only be a life interest because the king, I think he owned everything. So we shall see later that fiefment was not used to transfer interest smaller than life interest. So term years, the so-called terms for years. So like a leasehold. But for our purposes now, we may simply note that transfers of interest for life or larger were accomplished by livery of seisin. Seisin. So seisin. Another great one to go into here. So I guess we're going to take another dive into seisin and find out what we're talking about here because we're not talking about something you're going to put in the sauce. But yeah, so we have, let's see here. So dressing up is a seisin, and we're going to have to get to seisin. But I think we're done with fief here. As you can see there, it's a...
Our county observer says, I figured the narrator would be disabled after things began. Now I'm thinking I should be quiet.
No, feel free to pipe in there as long as it's something meaningful and applies either to either what I'm commenting on or the text at hand. This is how we do the live streams here because it's interactive, and that's why we have the talking chat enabled. Okay, so here we go. Seisin is where we're going to go next. I know we've gone on this on a previous stream, but this is this stream, so we're going to go towards seisin. Give me a second here and see if we can get there quickly. It's an S. And this is where we need to know this word, because the word cease with an S is just like seize with a Z, but they have opposite meanings, as you'll soon see. I think they do this on purpose. Kind of like you always find out the appellate case holdings, the names in those cases are usually funny names. And I think sometimes they only record the cases if they have a strange, outstanding name. All right, the R's. Here we go. All right, just passed a little bit, but we can jump back. Oh, here we go, sessions. And let's see here. It was mentioned in the livery, or meaning to be dressed up, I think, is what they're using that. I just can't use plain language in these kinds of things. It would be too accessible for people like us. So let's go along here. And the I's, well, I want to pass it here. Here we go, I just saw it. There it is, seisin, not salt. So it's from the 14th century, just like fief. It's a completion of the ceremony of feudal investiture. So we're seeing livery, the vestiture, by which the tenant was admitted into freehold. So it's a completion of the ceremony where the tenant, the person on the land, was admitted into freehold, meaning they have that indefinite or lifehold possession. 2, possession of a freehold estate and land. Ownership takes us to the fundamentals of property. Louisiana law. The right that the law accords universal successors to own and possess a person's estate directly and immediately upon that person's death. So that comes from your Louisiana Civil Code. It's also spelled seisin without the S, since it's pronounced like with a Z. Also termed vesture, seisin in Scots law, and seisin. So, all right, well, let's read more about seisin down here. Originally, seisin meant simply possession, and the word was applicable to both land and chattels. So possession, seisin was possession, session, seisin, possession. All right. Prior to the 14th century, it was proper to speak of a man as being seized of land or seized of a horse, simply in possession of land. Man being seized of land was in possession of land, or seized of a horse was in possession of a horse. Gradually, seisin and possession of a land, became distinct concepts. A man could be said to be in possession of chattels or of lands wherein he had an estate for years, but he could not be said to be seized of them. Seisin came to finally mean, in relation to land, possession under the claim of a freehold estate therein. The tenant for years had possession, but not seisin. Seisin was the revisioner who had the fee. Reversioner who had the fee. I think this is a meaning that can be disposed of or resold or whatever. And although the word seisin appears in modern statutes with a fair degree of frequency, it is usually treated as synonymous with ownership. And that's an introduction to Law of Real Property from 1988. So we see here that seisin and possession usually is distinguished between the freehold with a seisin, and possession could be for a term. Okay, but sometimes depends. Again, since it's used in modern statutes, check your statutes in your jurisdiction. Again, it's nice to know that a word like seize and seisin, see here, seize, to invest with seisin or establish a holder in fee simple, to put in possession. To seize is to put into possession. He became seized of half a section of farmland near Amarillo. So we have seize, S-E-I-S-E, pronounced just like the S-E-I-Z-E, but It's not, because here it is, seize is even older, from the 13th century, to forcibly take possession of a person or property. So even a person could be seized, but wouldn't be seasoned. To place someone in possession. To seize is to place someone in possession. To seize is to put in possession. So do you see how this comes into to be informed of or aware of something? So from seisin, seizure, but when we have a Z in it, even though they're pronounced the same, this is to forcibly take possession. And seisin was the completion of a ceremonial feudal investiture. So it's to invest, to put into possession, whereas to seize is to forcibly take possession from someone else. It seems to place someone in possession, and that's to place someone. And 3 is to be in possession of property, or to be informed of or aware of something. Seize the moment. Okay, so there it is. Nice deep dive into seasons and fees. So fees, fee, freehold, seisin, seize, possess. I think we got it clear. Let's continue with the presentation. All right, so we have here that from fee, as a general rule, only the owner of the fee, the freehold, has a right of action for damages to the fee, to the land, to the freehold land or property. A trespass on a right of property is actionable upon any physical invasion of it, physical, regardless of whether the invasion causes measurable damages, and an owner, whether he or she is in possession or not, may recover for injury to his or her property by the negligence of another. Further, the owner of any particular right, interest, or estate in real property, including one rightfully in the occupancy or possession of the realty, has generally at least a right of action for damages for injury to his or her particular right, interest, or estate. Thus, the holder of a non-possessory interest in property can generally sue for damage to that interest. And here's our observation that courts strongly disfavor the resort to forceful self-help in resolving property disputes. And I think that's the purpose of the courts. Let's go on to the next slide. We're on to section 47 here, and we go over the state law, the situs, and default judgments. So section 47, we go over the state law. This is what law governs in actions involving property. So what law do we choose to use? State law creates and defines property rights or interests. Generally, questions involving ownership of land are determined under state law, even when the federal government is a party. And the law of the situs, with the situs, the place of the action. So, in the law of the situs of the property controls. The law of the state in which the real property is located covers questions of property rights. For personal property, including intangible personal property, its situs is at the domicile of its owner. Interesting. So even intangible personal property, which is something that, if it's intangible, cannot be touched, seen, felt. It's something that's, this is intangible personal, so it's not an interest in land here, in an intangible personal property. Its situs will be at the domicile, so it's not, there is no connection to a physical geographical location for something intangible and perhaps movable. So therefore, what jurisdiction, what law is going to be controlling is going to be the one of the domicile of the owner. Interesting. So there will be domiciliary evidence in order to bring jurisdiction and standing in a particular court, it seems. Thus, the validity of a conveyance of a property interest is, now interest is the same as like a property right, a right to property, a right to the enjoyment use of, exclusion of others, etc. So the validity of a conveyance of a property interest is governed by the law of the place where the property is located. So for the personal property, it's in the domicile of its owner, and if it's a property interest, governed by the law of the place where the property is located. So the validity of a conveyance of a property interest. Okay, so that if you're selling a property or you're transferring it to someone else, is governed by the place where the property is located. And in determining the ownership of the property, the courts apply the law of the jurisdiction in which the land is located. So it seems like that you would pick the one that's closest to a physical location of property, and if there's no physical location that can be identified, then it goes to the domicile of its owner. A default judgment determining the title to real property is just as conclusive upon the issue of title to the property involved as is a judgment of this kind rendered in a contested case. Let's read this one again. So a default judgment determining the title to real property is just as conclusive upon the issue of title to the property involved as is a judgment of this kind rendered in a contested case. Okay, so I guess the conclusiveness is assumed, I guess, and same with the contested case. So here's our case. The law of the cited shall exclusively govern in regards to all rights, interests, and titles in and immovable property. Titles in and to immovable property. So one more time. The law of the citus shall exclusively govern in regard to all rights, interests, and titles in and to immovable property, real estate, right? Immovable, something that's stuck to the land. And that's Quinn versus Quinn in Nebraska, 2004. All right, we're on to section 48 here, and this is pleading and actions involving property. So let's look at the pleading ownership and property description. So we have pleading ownership here. One's ownership of real property may be sufficiently alleged by an averment that he or she was seized and possessed. Okay, let's break this before we go further here. One's ownership of real property, immovable, is like land. So one's ownership of real property may be sufficiently alleged by an averment. So you're making a statement that you're claiming is truth, a fact, that he or she was seized and possessed. So that was you were put in possession of, right? In a freehold. If you're seized and possessed, that means there is possession and seisin. So one's ownership of real property may be sufficiently alleged by an averment. So you're making an averment, a statement of facts that you believe is true, that you are seized and possessed of the land. A declaration or complaint should describe the real property in a suit with sufficient particularity to prevent the defendant from being misled or uncertain as to the location of the property. So that's an important part with pleading. But then there's a liberal construction in practice. Liberally read, a complaint of a dog owner against a city, alleging that a city police officer shot and killed the dog, encompasses a claim for damages for property loss. All right, let's move along. So we're on to section 49 with proof of ownership and formal proof of title. The ownership and possession of land must be proved by evidence and cannot be proved by general notoriety or by reputation. While the legal title to real property can be shown by a valid deed, the record title is the highest evidence of ownership of real property and is not easily defeated. When the issue of title or ownership is directly involved, The proper way to prove title to the property is by the production of the original documents or certified copies from the record. The deuces take 'em. The payment of taxes for real property is not evidence of title and ownership. Further, it has been held that title opinions are not evidence of title. So, testimony as proof. There are circumstances where testimony alone can be sufficient basis to establish ownership of property. When determining ownership for personal property with no formal title, oral evidence from a witness with knowledge concerning ownership of such chattels is competent evidence of the fact of ownership. Interesting there. And this is in regards to chattels or movable property. All right, we're on to section 50 now, the burden of proof. Ownership, prima facie, clear, convincing evidence. So we have different burdens here. Let's look at the burden of proving title or ownership of real property is upon the party alleging it. So the burden of proof is on the party alleging it. The burden of rebutting a prima facie showing of title rests upon the party attacking the title shown. And another person who claims ownership to that property must establish the claim by clear, satisfactory, and convincing evidence. That's that clear and convincing evidence, burden of proof. Here's our cases. As a general matter, title to estates and land should be altered only by clear expressions of intent. And that's the estate of Goldberg versus CIR in 2010. That was applying New York law. So as a general matter, title to estates and land should be altered only by clear expressions of intent. That's interesting there. This would be an interesting case to look at here, and this is got more references on that. All right, move on to section 51 and presumptions of ownership. Record and legal title. A record title or legal title is an indicium sufficient to raise a presumption of true ownership.
Audit term says, but what type of alteration?
Well, that would be for the jury to decide, it seems. Those are facts. I think that would be a fact for the jury, but let's see here. Again, we're on to the presumptions. We're seeing the burden of proof. Now we're on to the presumptions, like the record and legal title. A record title or legal title is an indicium sufficient to raise a presumption of true ownership. A deed is prima facie evidence of a grantee's ownership, meaning there was a grantor. There is a rebuttable presumption that the person whose name appears on a legal title is the property's owner. This promotes a state's public policy in favor of the stability of titles and the integrity of property transactions. Now we're on to possession. Possession of real property is prima facie evidence of ownership. Similarly, possession of personal property creates a rebuttable presumption that those in possession of property are rightly in possession. Evidence of possession of personal property ordinarily constitutes some evidence of ownership, which may be overcome by proof of ownership in another. So there's that burden. Possessions are pretty good. They say, possession's 9/10 of the law. But I don't think that's in this volume of American jurisprudence. I digress. Now let's look at name, brand, and markings. The name on tools, vehicles, or animals, and articles generally is commonly accepted as prima facie proof of ownership, and although not much of it probative weight, it is enough, in the absence of evidence to the contrary, to carry the issue to the jury. The brand or mark on cattle is prima facie proof of ownership in states where the legislature has permitted such branding by statute. That's interesting, the brand mark. But I think when you purchase it, your receipt is now title of ownership. And but until then, I think if people are stealing it or something, I think that just their brand mark would be sufficient as proof of ownership. So not too sure on that, but that's a pretty interesting perspectives. These are updates now from the last presentation I did, which was from 2011. This is a 2022 edition. So you figure 11 years of litigations in property. Might have things changed since then, even in 2022. But nonetheless, this is a lot more up to date. So let's look at the presumptions now of dissent and intestacy and the case authorities. So we have section 51. Property is presumed to descend to the heir in the absence of any proof to the contrary. The presumption is that a deceased person died intestate and that his or her heirs become the owner of all of his or her property. Exercising acts of ownership over property is the basis for a statutory presumption of ownership in some jurisdictions. So let's look at some of these cases here. Here's U.S. versus Nava here in Montana, 2005, applying Montana law in holding that a person possessed of the record title is presumed to be the lawful owner of property. We also have here with Huskinson versus Nelson in Idaho, 2012. So this is a newer one from the last presentation. A party with title to the disputed property is presumed to be the legal owner of the property. A party with title to the disputed property is presumed to be the legal owner of the property. All right, then we have a presumption exists that a sole recorded owner of real property is the sole owner of the property in Alaska, 2012. And we have under New York law, the party who possesses property is presumed to own it, and one who holds funds in a bank account possesses that account. And the presumption of ownership follows. Someone who holds funds in the bank account possesses that bank account. And this is in Ray Suntech Power Holdings and Southern District Bankruptcy in New York, 2014. And the New York Bankruptcy Court holdings usually hold a lot of persuasive weight in all jurisdictions pretty much due to, for some reason, I guess the litigious nature of New York. All right, let's get on to the best part of the presentation here with a lot of new stuff from the last one on motor vehicles, title certificates as evidence of ownership. Now, this is one a lot of people have asked questions on. Let's get down to the American jurisprudence perspective of this and see where all the pieces fall. So, starting with a generally, ownership of a motor vehicle is generally determined by reference to the title certificate. It is generally, which is presumptive, but it's the presumption here, by reference to the title certificate. A title certificate, not the title certificate is prima facie evidence that party named on the certificate owns the vehicle to which it applies, or creates a rebuttable presumption. There it is. As I said, this is a presumption, and it's a rebuttable presumption of ownership. But it is not conclusive proof or the sole determinant of ownership of a motor vehicle. Under such authority, proof showing different ownership is admissible. So think about that. Is that a certificate, title certificate, is only prima facie evidence that the party is the one that owns it, that's named on the vehicle. Now, which party? Depends on the certificate, right? Similar authority explains that certificates of title of automobiles. So we're looking at title certificates for motor vehicles. Now we're looking at similar authority that explains that certificates of title of automobiles are indicia of ownership and control, and that a certificate of title is merely evidence of title to a vehicle, not title or ownership itself. In other words, a certificate of title is not of itself proof of ownership or legal title to a vehicle. And a person may have legal title in a vehicle even though he or she does not possess a certificate of title. A title certificate is prima facie evidence that the party named on the certificate owns the vehicle to which it applies, but it is not conclusive proof or the sole determinant of ownership. A rebuttable presumption of ownership. All right, which brings us to the conflicting authorities and the fact question with motor vehicles. So the strict view, the title determines ownership. So, however, the other authority, we saw those previous authorities, the other authority holds flatly that the owner of a motor vehicle is the person to whom a vehicle is titled, or the person whose name appears as such on title certificate. Under such authority, indicia of ownership is only considered, it's only under consideration to determine ownership of a motor vehicle when no title has been issued to any party asserting rights to the vehicle. But we have the prevailing view. Ownership is a fact question. Vehicle ownership is in fact a question for the jury to determine in the light of all the circumstances. Where there is conflicting evidence of ownership of a motor vehicle, the issue must be resolved by a trier of fact. Key takeaway here is that these views are not always fully reconcilable in a majority of jurisdictions. A title certificate creates a rebuttable presumption subject to disproof by competent evidence. So it has to be competent evidence. But under the strict view, the title is treated as conclusive, absent a gap in the chain of title. The conflict is most acute when a party holds equitable or possessory ownership without formal registration. So we see here where the splitting hairs is, but we can also see the strict view, the prevailing view, and the conflict. So let's look at the cases and where the rubber meets the road with motor vehicles. The name on a vehicle's title raises a rebuttable administrative presumption of ownership. That was State Farm versus Scott in Texas, 2012. A registered certificate of title establishes only presumptive ownership of an automobile, which can be overcome by competent evidence. And that's Birmingham Fire Insurance versus Rosado, and that's Florida's 5th District Court of Appeals, 2010. I think it's a new case that wasn't on none of these have been on the previous presentation, it appears, because even if they're 2010, it probably would have made it to the 2011 version we were reading. Okay, we get a state's Motor Vehicle Certification of Title Act is the exclusive method of transferring title to a vehicle, but it is not conclusive of ownership. Now that's intense there. A state's Motor Vehicle Certification of Title Act. It's not even a statute. And this is McCooley versus, I'm not even going to say it, Nebraska 2016. Now we have the motor vehicle title documents are not unimpeachable evidence of ownership. So they can be impeached or silenced here. Motor vehicle title documents. That's applying California law, and that was 2010 in Ray Stinson. And then we have the title registration is rebuttable if evidence of ownership to the contrary is produced. And that's Agency Insurance versus State Farm Mutual Auto Insurance and Maryland 2010. All right. Some pretty interesting cases. So now let's look at these key principles at a glance here. We went over section 46, which are the property rights carry enforceable remedies. Trespass is actionable regardless of measurable damage. They could trespass your yard to plant pretty flowers, and it's still a trespass, even if you benefit, even if you like the flowers, even if they did it with good intent. It's a trespass is actionable. Courts disfavor forceful self-help. And Section 47, state law at the situs controls. Federal parties are not exempt. Default judgments on title are conclusive. Interesting there. And then Section 48, ownership may be alleged by seized and possessed. Property must be described with sufficient particularity. So Section 49 was the record title is the highest evidence. Tax and title opinions do not prove title. Testimony can suffice for personal property. So bring this into that motor vehicle one about evidence of ownership. All right, Section 50, the party alleging ownership bears the burden of proof. Challenges to prima facie title require clear and convincing evidence. So the party alleging ownership bears the burden of proof. Legal title, possession, name, brand markings, and descent each carry rebuttable presumptions of ownership. And finally, with Section 52, a vehicle title certificate creates a rebuttable presumption of ownership, an administrative presumption of ownership. Conflicting evidence makes it a question of fact for the jury. Right. So from that, it takes us to the best part of this presentation, to the fun quiz, where we're going to test our knowledge. So here's how we play this game. In the chat, you put in the number of the question you're going to answer, followed by the letter of your chosen answer. So if question 1, I was going to select letter D, I would put in the chat Arabic number 1, followed by the letter D delta. That would be my choice. If I decided to change it, I would put that same number in again, followed by my different choice here. And then that would be the last answer, would be my final answer. We'll tally up at the end and test our knowledge. Let's get started. Question 1. An owner of real property is traveling abroad when a neighbor contractor negligently demolishes part of the owner's garden wall. So the neighboring contractor, while this guy's away, demolishes part of his garden wall. The owner is not in possession. Which statement best describes the owner's right of action? A, no right of action exists because the owner was not in possession when the damage occurred. B, a right of action exists, but only if the owner can show the invasion caused measurable, quantifiable damage. C, the owner may recover for injury to his or her property caused by the negligence of another, whether he's in possession or not. Or D, only the holder of the fee simple in possession may sue. Holders of lesser estates have no standing. So, we got a little curveball in here. Let's see, anyone wants to take a stab at question 1. Is it 1, no right of action exists? 2, the right of action exists, but only if they can show measurable, quantifiable damage? Is it C, the owner may recover for injury caused by the negligence of another, whether he's in possession or not? Which best describes the
Joseph
owner's
figure
right?
5227 says 1C. Craig Curry D3T says 1C.
All right, so we got 2 for 1C. I think that's a pretty good selection. And then the last one was only the holder of the fee simple in possession. May sue. Okay, good. Good call, guys. Let's move to the next one. Question 2. A California domiciliary. So this is someone that has their domicile, their place of living, their abode is in California. They own a portfolio of patents and corporate bonds, so personal property. She dies, and her estate is contested. What law governs the ownership questions for those intangible assets? So she has some intangible assets. Those are those patents and corporate bonds. There's some people contesting it. Goes to court. What law will govern this now? Will it be A, federal law because patents are creatures of federal statute and bond markets are federally regulated? Is it B, California law? For intangible personal property, the situs is at the domicile of its owner. Is it C, the law of whichever state issued or registered each individual instrument? Or is it D, the law of the state in which the descendant's estate is being probated regardless of domicile? All right, this one's a little bit easier. Anyone have a stab for question 2? Is it going to be the governing law for this case? They're contesting her assets here. Is it going to be federal law?
Craig Curry D3T says 2B.
2B. We got one for 2B. Any other takers for question 2? Going once, going twice. Going on to question 3. All right, question 3. We're going to do this one on the proof of ownership and the burden of proof. At a trial, a claimant offers 3 items to prove she owns a disputed parcel. 1, a title opinion from a licensed attorney. 2, 15 years of property tax receipts. And 3, certified copies of the recorded deed. Which combination correctly states what the law recognizes as evidence of title? A, all 3 are evidence of title. The jury weighs each according to its probative value. B, the title opinion and the tax receipts together create prima facie evidence. The deed merely corroborates. C, the tax receipts are the strongest evidence because they show continuous, uninterrupted possession. Or D, only the certified copies of the recorded deed constitute evidence of title. Title opinions and tax payments do not. So which is it for question 3? Is it A, all 3 are weighed by the jury? B, the title and the tax receipts are enough for prima facie evidence? Is it C, the tax receipts are the strongest because they show continuous possession? Or is it D, only the certified copies of the recorded deed constitute evidence of title? Any takers for question 3?
Craig 3D3T says 3B.
3B. Any other takers for question 3? Again, this is about the burden of proof, and at a trial, the claimant offers 3 items to prove a disputed parcel. Now, which combination correctly states what the law recognizes as evidence of title? Okay, so there it is. So you picked
Joseph figure 5227 says 3D.
All right, we got one for 3D. All right, any other takers for question 3? Anyone else still here in the chat wants to take one on question 3? Is Audit Them still there? Anyone else? Howard County? Let's move along. We're going to question 4. Oops. Wrong way. There we go. Question 4, motor vehicles. In a dispute over who owns a motor vehicle, the plaintiff
Audit term says forfeiture.
Forfeiture. All right, 4. In a dispute over who owns a motor vehicle, the plaintiff produces a valid, uncontested certificate of title bearing her name. The defendant offers other evidence of actual ownership. Under the majority rule, what is the legal effect of the certificate? A, it creates a rebuttable presumption of ownership. The defendant may overcome it with competent contrary evidence. Or B, it is conclusive proof of ownership. No intrinsic evidence of a different owner is admissible. C, it is merely a regulatory document with no bearing on ownership in civil litigation. Or is it D, it shifts the burden to the defendant to prove ownership?
Howard County Observer says, still here but not trying to guess answers, so I'll just listen.
Yeah, but guessing's fun. All right. Because it still makes you think. There's a commitment involved with putting an answer in. So then you have some skin in the game, so to speak. All right, so this one here is a pretty complicated one. It's a dispute over who owns a motor vehicle. Now, the plaintiff produces a valid, uncontested certificate of title bearing her name. But the defendant offers other evidence. You don't say what kind of evidence, but he offers evidence.
Craig 3D3T says 4D. Howard County Observer says, I'll pass.
All right.
Thanks.
All right, so we have one for 4D here. It shifts the burden to the defendant to prove ownership beyond a reasonable doubt. All right, so we have all our answers in. So answers A and D are pretty similar here, as you see here. For the defendant, it creates rebuttable was legal effect of the certificate. This is the certificate that the plaintiff produces that either it creates a rebuttable presumption of ownership. The defendant may overcome it with competent contrary evidence, or D, it shifts the burden now to the defendant to
Audit
prove.
term says it'll be cool if you made a final screen with everyone's answers or passes fail.
Yeah, but then people get upset and they don't want to participate. It's hard enough to get people to take guesses, let alone own up to them at the end. But I digress. All right, we're on to the finals. You got to answer question 3 if you're going to be here now. Let's go back to question 3. You can throw in trial. Claimant offers 3 items to prove she owns a disputed parcel. You give a title opinion from a licensed attorney, 2 15 years of property tax receipts, and 3 certified copies of the recorded deed, which combination correctly states what the law recognizes as evidence of title. That A, all 3 are evidence. The jury weighs each according to its probative value. B, the title opinion and the tax receipts together create prima facie evidence. The deed merely corroborates. C, the tax receipts are the strongest evidence because they show continuous, uninterrupted possession. Or D, only the certified copies of the recorded deed constitute evidence of title. Title opinions and tax payments do not. All right, so we went through that question twice. Anyone else wants to take a stab at 3? We have 4 with the motor vehicles, and there's a dispute. Under the majority rule, what is the legal effect of the certificate? So the majority rule. So we have our answers in. Let's get to the final slide here and test our knowledge, see how well we did. And here we go. So for question 1, the owner of the real property is traveling abroad. Contractor knocks down the wall. Correct answer was C. The owner may recover for injury to his or her property caused by the negligence of another, whether in possession or not. Because we saw in the first section here we went over that Section 46 expressly removes possession as a condition for recovery of negligent damage. All right. That was a pretty straightforward and simple one. And let's see here. I think we got that one right
says
there.
18 people in here, but only 6 thumbs up. Come on, you all get it together and hit the thumb up. This is the only channel in the world bringing you this education.
Well, thank you and salute. We did have a correct answer here from Joseph. So excellent. Let's move on to the next one here. Question 2. A California domiciliary owns a portfolio of patents, and then she dies. What law governs the ownership questions? So it's going to be B. California law for intangible personal property. Situs is at the domicile of its owner. We saw in Section 47, it fixes the situs of intangible personal property at the owner's domicile, not any other physical location. So 2B, and let's see here. Excellent. Yeah, Craig got 2B correct. Anyone else take anyone on 2B?
Howard County Observer says, the narrator definitely causes me to be more quiet, which I don't need help with, LOL.
No worries. Let's continue on here. All right, so on question 3. At trial, a claimant offers 3 items to prove she owns a disputed parcel. Title opinion from a licensed attorney, 15 years of tax receipts, and certified copies of a recorded deed. Which combination correctly states what the law recognizes? And the correct answer was D. Only a certified copy of the recorded deed constitutes evidence of title. Title opinions and tax payments do not. And Section 49 states that tax payments and title opinions are not evidence of title. Record title is the highest evidence. And finally, with question 4. Let's see, on question 3, Craig got question 3 right. Excellent. See, that's 1C. All right, let's see, where is it? 3D. Where did I saw it there? Joseph Figueroa got 2D. 3D. I'm looking at too much here. All right, let's go on to question 4. In a dispute over who owns the motor vehicle, there's the plaintiff that produces a valid, uncontested certificate of title bearing her name, but the defendant offers other evidence, actual ownership. Correct answer is A. It creates a rebuttable presumption of ownership. The defendant may overcome it with competent contrary evidence. He has evidence and needs to be competent to overcome it. That's going to be, looks like, the jury to decide, because the majority rule. The certificate is prima facie evidence only. Proof of different ownership is admissible. So 4A, let's see who they wouldn't participate on that one. Craig got close. 4D was a very close one there. That was one of the tricky ones to get you off track. And I made this one extra challenging just to make sure it's different from the last, because we just went over the property in American jurisprudence, and this is really the update coming from 2022. So it's really not that old considering these kinds of documents. And I thought that the changes we've seen here in these sections here really hit home for a lot of people, and it might be a good time to bring this here to the channel and to go over it again now that we just did the whole section on property. So this should round out our whole American jurisprudence study on property and property law. I hope you all learned a lot about the distinctions of property and how it's not just the things that you think it is, but the rights associated with the ownership and all those interests and rights and benefits that come with it. That said, I would thank you all for attending, and I hope to see you all on the next one. Peace out.
Our county officer says, I can't get down with the whole USA is the totality of America crap. It isn't.